Hi, my name is Jairaj and today we are talking about the Industrial Relations Code 2020. This code deals with matters related to industrial disputes, regulation of trade unions, and standing orders in industrial establishments.
The code replaces three existing acts: the Industrial Disputes Act 1947, the Trade Unions Act 1926, and the Industrial Employment Standing Orders Act 1946. In addition to merging the provisions of the three acts, the code makes some changes. Today, industrial establishments hiring 100 or more workers need government permission for closure, layoffs, or retrenchments. The Industrial Relations Code raises this to 300 and allows the government to further increase this limit by notification. There are a large number of registered trade unions in India today, many of them within the same establishment. The code introduces certain criteria for the trade union which will be at the negotiating table with the management during a dispute. If there are several trade unions within the organization, then the trade union with support of at least 51% of workers will be recognized as the sole negotiating union by the employer.
The Industrial Relations Code also introduces provisions to employ fixed term labor and in between option between permanent employees and the contract workers. As per the code, the fixed term employees, the FTEs, will get all statutory benefits such as social security, wages, etc. on par with the permanent employees who are doing work of similar or same nature.
Under the code, both parties, that is, the employer and the employee, must give a prior notice of 14 days before a strike or a lockout. This criteria at present is only for public utility services such as airlines and railways under the Industrial Disputes Act 1947. The code extends it to all establishments which may impact the workers' right to strike.
The 1947 Industrial Disputes Act provides an elaborate mechanism for resolution of disputes between the workers and establishment. The Industrial Relations Code 2020 simplifies its structure.
In cases of disputes, the central or state governments may appoint conciliation officers to mediate and promote settlement. These officers will investigate the matter and hold conciliation proceedings to arrive at an amicable settlement. If no settlement is reached, either party can approach industrial tribunals constituted under the code. The central government may also constitute national industrial tribunals for settlement of disputes which involve questions of national importance or involve multiple states. The code removes the additional authorities of courts of inquiry, conciliation boards, and labor courts in the conciliation and adjudication process.
The code also brings in a few other changes.
The code changes the composition of tribunals from one-person to two-person tribunals. Tribunals will now have one judicial member and one administrative member with the specified qualifications.
The central and the state governments have been given certain powers with regard to the judgments or the awards which are given by these tribunals. The central government can defer the enforcement of an award given by the tribunal in case where the government is a party in dispute or the award has been given by a national tribunal. The central or the state governments have the powers to modify or reject any of the awards which are given by these tribunals. It is worthy to note that in 2011, the Madras High Court had rejected similar provisions in the Industrial Disputes Act 1947 on constitutional grounds.
A full analysis of the code is linked in the description below. Watch the other videos in this series to know more about the labor codes.